Hello everyone, my name is Scott Aubrey. I'm the owner of Aubrey Law. We do estate planning and probate, and today I'm going to talk to you about 3 simple ways to avoid probate costs. But before we get started, if you have any question about today's topic or any questions about estate planning and probate, you can go to aubreylegal.com and schedule a time to talk with me for free on the phone about any questions you have regarding estate planning or probate. So today's topic is 3 simple ways to avoid probate costs. So probate is something that I think most people have heard about, and it's usually something that people want to avoid. It's one of the common questions I get with potential clients is, what is the best way to avoid probate? Because maybe they have just gone through the probate process with a family member, or they talk to a friend who's had a difficult experience getting the probate process resolved. So they want to find out ways they can do it. And there are a lot of ways you can do it, but there are 3 simple ways you can do that. The first way is to name a beneficiary. This would be for annuities, life insurance, investment accounts, retirement accounts, even bank accounts. These are type of accounts that allows you to name the beneficiary of that account when you die. So what happens is that you'll fill out paperwork at the institution. You'll name who you want to receive that property after you die, and upon your death, that property is automatically transferred to that person outright without any sort of restrictions. They just have to just fill out certain paperwork, prove that the person has died, and then the institution will forward on that account to the person who it's attended to. There are some limitations with this, using this strategy. Number 1 is that there's no restrictions on how that person receives that money. So if you were to have an account and leave it to someone who is 18 years old, and they're the primary beneficiary, when they turn 18, that money they receive from that account is free of any restrictions, so they can use it for whatever they want. So if you would want them to use that money for education or potentially buying a house, there wouldn't be any ways you can control that. They can do it whatever they want with it. So just be cautious that when you do name individuals as a beneficiary, make sure that you feel that they are able to handle that money if something were to happen to you and they would receive that money at a young age. Another thing to be concerned about with beneficiary designations is you need to make sure that you stay up to date on those, and that you're reviewing them on a every so often to make sure that the person who receives that account, or who is the primary beneficiary, is still who you want to be. I see this a lot when people get divorced. They forget to update their primary beneficiary from their ex-spouse to someone different, and then the person passes, never updating their beneficiary designation, and their ex-spouse ends up receiving an account that they never intended for them to have. So just make sure you're looking at your beneficiary designations on every so often to make sure they still go to the people that you want to. Another way to simply avoid probate costs is through joint ownership. And what this is just adding someone as a joint owner on an account or on a piece of property. And what will happen is that once you die, that property will automatically go to that other joint owner. Probate is not involved. It just happens as a matter of law, since they are the joint owner and they're the surviving owner of that property. I see this strategy used often with elderly parents, is that a child will put their name on a bank account of an elderly parent. That way it allows them to help manage them while they're living, and also to make for the ease of transfer when they die. This is another strategy that you have to be somewhat careful about using, because there can be unintended consequences of doing it this way. Number 1 is that if you are the joint owner of property with someone else, that person's creditors are able to attach property that they are joint owners of. So if that person is a joint owner and then they were to get sued, and there was a lawsuit against them and there's a judgment against them, they could go after that joint owner, that joint property that you own with them, to regain that lawsuit or regain that judgment. So you have to be careful with that, because you want to make sure that the asset is protected while you're living, and it doesn't fall into the hands of someone else that you don't want them to, even though you only intended to have them have that property after you die. The third simple way is to create and fund a revocable trust. What that will allow you to do is create a trust during your lifetime, you'll transfer assets into that trust, and upon your death, the trust controls those assets, and they will distribute them according to the terms of their trust. This is probably the simplest way to do it. It definitely gives you the most control. You're able to control when your beneficiary receive the property of that trust. You can stage it so they only receive it at certain ages, upon the happening of certain events. So you have a lot of flexibility on determining how and when your beneficiaries receive any assets or money that you receive to them. But the one thing you do have to be concerned about when you create a trust is that you make sure the trust is fully funded. And what that means is that you transfer assets into the name of the trust. And how do you do that? What you do is you retitle the assets from you individually to the name of the trust. That way the trust is now the owner of that property. Therefore, when you die, you are not the owner. Therefore, it avoids a probate process. The court does not have to oversee the distribution of those assets to the beneficiaries. The trust and trustee control that process. So just to recap, the 3 simple ways to avoid probate costs. Number 1 is through named beneficiaries. Number 2, joint ownership of property. And number 3, revocable trust. But the thing to remember with the first 2, with joint ownership and beneficiaries, is that you have less control of how the beneficiaries receive those assets. So just make sure that that's something, if you're not concerned about that, then that's okay. But if you are concerned about when the beneficiary receive those assets and how, then a trust may be the better option. But really the best thing to do is probably talk to an estate planning attorney about that to see what strategy is best for you to avoid probate costs. So that's all I have for you today. Again, my name is Scott Aubrey. I'm the owner of Aubrey Law. If you have any questions about estate planning or probate, you can go to aubreylegal.com and schedule a time to talk with me for free on the phone. So please do so if you have any questions. Thank you for taking the time to watch this video. I appreciate it. I appreciate you, and I will talk to you again soon.